Hello and welcome to our podcast on intellectual property agreements. The focus of today's podcast is assignments versus license agreements versus work-for-hire agreements. Our objective is to learn how to differentiate among the many different ways to obtain and divest ownership of intellectual property. With an assignment agreement, the owner of the intellectual property is transferring all rights in the property to another person. This is an agreement that should be in writing and signed by the person who is the owner. That is, the person who is assigning the property to someone else. The magic words, as we call them in the law, are that you are transferring all right, title, and interest in and to the property, and you would define the property within the body of the agreement. Now, who owns assigned property? Well, the assigned property, after the assignment is executed, will be owned by the purchaser. The person who created the intellectual property in the first place and who did the assigning will no longer have any interest in that property. The purchaser is the one who paid money or other consideration to acquire all rights in the property, and therefore they will now own it. A license agreement is a temporary transfer of some of the bundle of rights that an owner owns in the intellectual property. A license is a right to use the property. It does not transfer complete ownership like an assignment does. Now, there are two types of licenses. A license can be an exclusive arrangement or a non-exclusive arrangement. The exclusive license gives the licensee, or the recipient of the rights, the right to be the only person who can exercise the rights given in connection with the property. An exclusive license must be in writing. An example of an exclusive license may be when a musician signs with a record label and gives the record label the exclusive right to promote music performed by the artist. This would prevent the artist from going to a rival record label and releasing an album at the same time that the first label is promoting the artist. With a non-exclusive license, the owner of the property is telling the licensee that they are not the only one who may be given that bundle of rights. In fact, the owner may allow many other people to exercise that same bundle of rights. For example, if you have a successful band and you have a logo for the band, you may give one t-shirt manufacturer a non-exclusive license to reproduce the logo in connection with t-shirts. You may give another manufacturer the non-exclusive right to reproduce the logo in connection with knit hats. Or, if you run a website, you may give a non-exclusive license to all the users who come to the website to use the website services and software. When many people are allowed to use the property in the same way, the license is non-exclusive. Who owns the licensed property? Well, the licensor. This is the owner of the intellectual property. And remember, a license agreement does not give up all right, title, and interest in and to the property. That's an assignment agreement. While a licensee pays some sort of consideration, whether it's money or a promise of some sort, he or she does not own the property under a license agreement, even if the license agreement is exclusive. Let's turn now to works for hire. A work for hire is a creative work that is owned by an employer by operation of law, even if the employer did not directly create the work. There are two categories of works for hire. The first is when employees create work in the scope of their employment. In this situation, the employer is always the owner of the work. The second category is when independent contractors create the work. In order for work done by an independent contractor or freelancer to be considered owned by the employer who paid for the work to be done, several conditions must be met, including a written signed agreement containing a work for hire clause. Who owns a work for hire? The work for hire is owned by the employer, whoever paid the employee or independent contractor for the work, provided it meets the requirements of being a work for hire. Work for hire is a copyright concept and applies in the case of asking someone to create a copyrightable work, such as computer code or design or script. There are 9 categories of goods that can be considered works made for hire under the copyright laws of the United States. The first category is a compilation of material. The second is a contribution to a motion picture or other audiovisual work. Next is a contribution to a collective work, such as individual articles collected for a magazine. Fourth is a supplementary work, such as a foreword, an afterword, a chart, or an illustration to a book. Fifth is a translation. This applies if you are hiring someone to translate the work into another language. The next 4 are very specific. They are an atlas, instructional text, a test, or the answer material for a test. If the category of work for which you're hiring a freelancer falls within one of these 9, then the work has the potential to become a work made for hire that is owned by the employer and not by the independent contractor. In addition to falling within one of the 9 categories, the work must be specially commissioned or ordered by the employer. It is not sufficient for a person to order one of a series of works from the freelancer. For example, if you're looking at an artist and the artist has made 45 signed lithographs, by purchasing one of those lithographs, you are not going to become an employer under the work for hire clause. That work, that signed lithograph, was not made pursuant to a special order from you. It was something that the artist had already conceived and created, and therefore would be owned by the artist, absent an assignment. On the other hand, if you request that a sculptor produce a sculpture to your specification and you start the project and he is doing that sculpture specifically because you as an employer ordered it, then that sculpture could qualify as a work made for hire. Another requirement is that the agreement commissioning the work must be in writing and signed by both parties, and further, it must contain specific work for hire language. This means that the agreement will say the work created pursuant to this agreement is being created as a work made for hire under the copyright laws of the United States. If all these factors are present, then the work may qualify as a work made for hire, provided the contract was signed before the freelancer started working on the project. If one waits until after the project has been started, then there could be a question. In that circumstance, the contract should include additional language assigning the work over to the person who is paying to have it done. So what is not a work made for hire? Well, there are a few things. First, any work created by an employee outside the scope of employment, using the employee's own resources and on their own time. Those would not be works that are owned by the employer absent an agreement to the contrary. Another category of work that would not be a work for hire is work created by an independent contractor where the agreement between the contractor and the person ordering the work was verbal or was written and signed but did not contain the language that the work created pursuant to the agreement is a work made for hire under the copyright laws of the United States. A final category of work that is not a work for hire is when the work does not fall into one of the permitted categories of works for hire that we went through earlier. In any of these cases, if you want to acquire ownership of such a work, you would want to use assignment language. Without the assignment language, the work will continue to belong to the creator, and the person who paid for and ordered the work will simply have a license to use the work, but will not own all right, title, and interest to the work. So now you can tell the difference between an assignment and a license agreement, know when a work for hire situation may or should arise, and know which agreement to use when acquiring or transferring ownership of intellectual property. Thank you for listening.